Welcome back to Canadian Justice, where we're discussing a legal challenge to prohibitions on sex work and the Ontario Superior Court decision dismissing that legal challenge. Jen was one of the represents one of the parties who brought this legal challenge. Jen, I want you to explain to our viewers why they should be concerned about this issue, because you know a lot of sex workers, not all but a lot, are marginalized. They're from marginalized communities, and there's often a struggle for the public at large to connect with the difficulties or see themselves reflected in the challenges of marginalized communities. So what can you say to the viewers to help them understand why this case and the stories of these women matter?
Yeah, thank you for asking. People are often very scared to publicly support sex workers. There's a lot of private support, even in conservative governments. When we've done lobbying efforts in the past, we'll say in private, I really support your efforts to decriminalize sex work, but I can't because the political party line isn't such that. And that's just because of a lot of conservative and religious values that drive the ideas of marriage and sexuality. But the rights of sex workers is really and should be really important to everybody, because the struggle that people should be connecting with is around, well, many, but one is just of bodily autonomy and the right for people to do what they need to do in order to make money to survive and to pay basic needs for their families, for their rent, paying for school or whatever people are using their sex work money to pay for. It's also about recognizing people's rights to make decisions, even if they're not decisions that somebody else would make. It's extremely patronizing to be told, "Oh, you don't know how much of a symbol of the patriarchy you are, and so you can't make decisions for yourself." And nobody would say that of women in poverty. You're too poor, you can't make decisions for yourself. And so we need to recognize sex workers' capacity to make decisions for themselves in life. And where sex workers aren't deciding to sell sex, we call that abuse, and that needs to be addressed as such. So the right to bodily autonomy is one that people should understand, not as a progressive right, but one as just as a very basic human right. And that's just sort of one level of why I think it should connect with general public.
Now, one of the things that stood out to me in the decision dismissing this challenge is the court said the question of whether selling sex is inherently exploitive, that is not relevant to the analysis. Um,
Mm,
the court said it's not relevant. They sure did spend a lot of time talking about it, including how
yeah.
recruitment and coercion and trafficking can take place. What's your reaction? Do you think it is relevant to the analysis or not?
Well, the court's role was to look at the objectives of the law, and the court actually the judge actually made that quite clear in the decision, that a lot of the reasoning was based on what Parliament set out to do, and that he's not there to decide what Parliament set out to do. So if Parliament made sex work illegal because it is exploitative, and that was considered a de facto reasoning for the objective, then yes, it is part of the analysis. And it also was part of the analysis for anybody who's read the 150-page decision. So it's not true to say that like when the judge said that it wasn't part of the analysis, it actually was part of the analysis if you read the decision. It's also, yeah.
That's why I asked.
Well, that's it. And so I think the that contradiction sort of needs to be addressed, but also there's no evidence to suggest that sex work is inherently exploitive. And that's important. There was no evidence submitted by the Crown, and there was a ton of evidence submitted by sex workers to say that sex work itself wasn't inherently exploitative, but that the conditions and everything around it, and particularly criminalization, fosters exploitation. And so of course, it's a part of the analysis, even though the judge shouldn't be determining whether sex work is or isn't exploitative. The evidence should be sort of speaking to that. And all of the evidence that that the Crown relied on, what the police evidence that they relied on, has police officers just giving their opinion about sex work as exploitation. So the decision did rely on that evidence anyways. So I don't want to say it's a lie, but it's really just not true that the court judgment didn't engage that.
So I'm going to pose a question. We're going to have to go to break before you can answer it. But I think
Okay.
what it seems to me, it seems like, and I don't want to jump to a conclusion, but it seems the starting point for you, for your organization, is an objection to the prohibition at all. I mean, the starting point for the court is to say
Mm.
that sex work is not legal, the purchase of sex is prohibited, sellers are immune. But at a fundamental level, I want to ask you when we come back from this break, is is your objection the legal status of sex work as a whole, not just these particular prohibitions. And before we go to break, I also want to I want to let you know I'm going to ask if you're going to be appealing this decision because it's a major one, and I
We
be
are, we've
curious. And
already
I think
filed our notice.
you have filed your notice to appeal.
Yeah,
Okay,
on the 18th, we filed our notice for
so
appeal.
let's go to break, and then when we come back, we're going to ask that question about the fundamental nature of the case.